Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Understanding Business 2024. Bonus Chapter A. Narrated by Omar Mohsen Ibrahim Fouad. Bonus Chapter A. Working Within the Legal Environment. Page 557. Learning Objectives. After you have read and studied this bonus chapter, you should be able to define business law, distinguish between statutory and common law, and explain the role of administrative agencies. Define tort law and explain the role of product liability in tort law. Identify the purposes and conditions of patents, copyrights, and trademarks. Describe warranties and negotiable instruments as covered in the Uniform Commercial Code. List and describe the conditions necessary to make a legally enforceable contract, and describe the possible consequences if such a contract is violated. Summarize several laws that regulate competition and protect consumers in the United States. Explain the role of tax laws in generating income for the government and as a method of discouraging or encouraging certain behaviors among taxpayers. Distinguish among the various types of bankruptcy as outlined by the Bankruptcy Code. Explain the role of deregulation as a tool to encourage competition. Page 558. Getting to know Scott Boras, baseball attorney.
Getting to know Scott Boras, baseball attorney. Professional athletes work incredibly hard to earn a place in the big leagues, and they expect their paychecks to match their status once they reach the summit of sports. Of course, teams with budgets to consider are often unwilling to pay out the multi-million-dollar contracts that some players demand. That's where deal makers like Scott Boras come in. A self-described baseball attorney, he prefers the term over sports agent. Boras has negotiated blockbuster contracts for Major League Baseball MLB stars since the 1980s. His name is all over the record books, the first agent to land deals for players worth $50 million. His name is all over the record books, the first agent to land deals for players worth $50 million, $100 million, $200 million, $250 million, and $300 million. All told, his company manages more than 100 active player contracts worth $3.83 billion, earning Boras and his employees $191 million from commissions alone. Long before he began brokering MLB deals, though, Boras dreamed of signing his own name on a contract for a major league team. He grew up on a dairy farm outside of Sacramento, California, obsessing over baseball, much to his father's chagrin. As a teenager, Boras wired a transistor radio into his cap so he could listen to Giants and Athletics games while he did his chores. Then one day he drove the family tractor into a hole he didn't notice, breaking an axle and injuring himself in the process. His dad made sure to destroy the distracting radio set before he helped his son. His ailing son. But Boras's passion for baseball could not be so easily stopped. He continued to pursue a professional career even after he moved on to college. Enrolling at University of Pacific, Boris played center field while studying industrial pharmacology, taking a wide range of classes from anatomy to zoology. He would often play a doubleheader on Saturdays, followed by a couple 3-hour labs, a process he would then repeat on Sunday. Boris planned to get drafted by an MLB team, enjoy a career in the big leagues, and then head to law school so he could earn a JD and practice medical law. A few weeks before the 1974 draft, however, he collided with another outfielder and injured his knee, causing him to miss his big chance. Boris played in the minor leagues for a few years, but he never managed to break into the majors. Although he fell short of his goal to play baseball as a top professional, Boris discovered some new interests during his years in the minors that would change the course of his career. He sympathized with the players who got cut from his team after spring training, athletes with no educational backgrounds or backup plans once their baseball dreams died. Boris started to see baseball players as a labor force who needed advocates for their rights. He also began taking a deeper interest in the statistical and technical aspects of baseball, qualities that would drive his success as a sports agent. After his playing days ended, Boris returned to University of Pacific to earn his law degree and took a job with a pharmaceutical defense firm once he graduated. Of course, his heart never left baseball, and in the 1980s, he put his legal expertise to use negotiating player contracts. Boris made a splash in the business almost immediately as he brokered one of the biggest deals in MLB history shortly after leaving his medical law job. This initial $7.5 million contract was outdone numerous times over the years as Boris broke record after record, negotiating a contract worth over $50 million in 1997, followed by a $252 million deal for Alex Rodriguez in 2000. Nearly 20 years after this legendary deal, Boris brokered the largest free agent contract in North American sports history when he landed a $330 million deal for Bryce Harper. Massive contracts like these happen after hours of intense legal wrangling, driven by statistics and rigorous fact-based arguments. Along with relying on Boris's legal knowledge and negotiating skills, his company also employs a state-of-the-art analytics team that rivals the stats operations at any major league franchise. These attributes have made Boris Corporation the undisputed champion of American sports agencies, allowing its owner to continue advocating for the rights of professional athletes at the highest level. Legal issues affect almost every area of our lives and businesses. The United States has more lawyers than any other nation in the world and is clearly the world's most litigious society. In this bonus chapter, we will look briefly at the structure of the U.S. legal system. Then we will discuss key areas of business law such as torts, patents, copyrights, trademarks, sales law, contract law, laws to protect competition and consumers, tax law, and bankruptcy law. We will also look into the sometimes controversial topic of deregulation. It's unlikely you'll be able to go head-to-head with a lawyer of Scott Boris's ability after reading this chapter, but you can use it as a foundation to the study of law. Who knows what your future might be? Sources: Brett Knight, The Most Powerful Sports Agent, 2022. Scott Boris is in a league of his own. Forbes.com, November 17th, 2022. Stephanie Epstein, Before Ruling Baseball, Scott Boris Failed at Baseball, Sports Illustrated, SI.com, May 13th, 2020. Matt Snyder, why Scott Boras has a compelling Hall of Fame case after years as MLB's top agent. CBS Sports, CBSSports.com, February 7th, 2023. Scott Boras, MIT Sloan Sports Analytic Conference, SloanSportsConference.com, accessed April 2023. Page 559, Bob Levy and Getty Images Sport and Getty Images. Name that company. This well-known technology company is looking to expand its market reach into the video game market by acquiring one of the leading companies in the industry. The U.S. Justice Department Antitrust Division is carefully evaluating how this merger would affect competition. Name that company. Find the answer in the chapter. The Case for Laws, LOA-1, define business law, distinguish between statutory and common law, and explain the role of administrative agencies. Imagine a society without laws. Just think. No speed limits, no age restrictions on the consumption of alcohol, no limitations on who can practice law or medicine. A society where people are free to do whatever they choose with no interference. Obviously, the more we consider this possibility, the more unrealistic we realize it is. Laws are an essential part of a civilized nation. Over time, though, the depth and scope of the body of laws must change to continue reflecting the needs of society. The judiciary is the branch of government chosen to oversee the legal system through a system of courts. The U.S. court system is organized at the federal, state, and local levels. At both the federal and state levels, trial courts hear cases involving criminal and civil law. Criminal law defines crimes, establishes punishments, and regulates the investigation and prosecution of people accused of committing crimes. Civil law proceedings cover non-criminal acts, marriage, personal injury suits, and so on. Both federal and state systems have appellate courts that hear appeals from the losing party about decisions made at the trial court level. Appellate courts can review and overturn these decisions. The judiciary also governs the activities and operations of business, including hiring and firing practices, unpaid leave for family emergencies, environmental protection, worker safety, freedom from sexual harassment at work, and more. As you may suspect, business people prefer to set their own standards of behavior and often complain that the government is overstepping its bounds in governing business. The financial crisis of 2008 highlighted that the U.S. business community did not follow acceptable standards, particularly in financial markets. This caused the government to expand its control and enforcement procedures. This chapter will look at specific laws and regulations and how they affect businesses. Business law refers to the rules, statutes, codes, and regulations that provide a legal framework for the conduct of business and that are enforceable by court action. Business law refers to the rules, statutes, codes, and regulations that provide a legal framework for the conduct of business and that are enforceable by court action. A business person must be familiar with laws regarding product liability, sales, contracts, fair competition, consumer protection, taxes, and bankruptcy. Let's start by briefly discussing the foundations of law and what the legal system is all about. Statutory common law. Two major fields of law are important to business people: statutory law and common law. Statutory law includes state and federal constitutions, legislative enactments, treaties of the federal government, and ordinances, in short, written law. Statutory law includes state and federal constitutions, legislative enactments, treaties of the federal government, and ordinances. In short, written law. You can read the statutes to make up this body of law, but they are often written in language whose meaning must be determined in court. With over 1.3 million licensed lawyers, the United States has more lawyers per citizen than any country in the world. Page 560. Rich Leg and E+ and Getty Images. In the U.S. judicial system, judges are guided in their decisions by the precepts of common law, often called unwritten law, because it is based on previous court decisions. Such decisions become precedent and assist other judges in making legal rulings. What are some practical benefits of this process? Common law is the body of law that comes from decisions handed down by courts. We often call it unwritten law because it does not appear in any legislative enactment, treaty, or other written document. Under common law principles, what judges have decided in previous cases is very important in deciding today's cases. Such decisions are called precedent, and they guide judges in the handling of new cases. Common law evolves through decisions made in court. Common law evolves through decisions made in trial courts, appellate courts, and special courts, like, for example, probate courts or bankruptcy courts. Lower courts, trial courts, must abide by the precedents set by higher courts, like, for example, appellate courts, such as the U.S. Supreme Court. Administrative agencies. Administrative agencies are federal or state institutions and other government organizations created by Congress or state legislatures with delegated power to create rules and regulations within their given area of authority. Legislative bodies can create administrative agencies and also terminate them. Some administrative agencies hold quasi-legislative, quasi-executive, and quasi-judicial powers. This means that an agency is allowed to pass rules and regulations within its area of authority, conduct investigations in cases of suspected rule violations, and hold hearings if it feels rules and regulations have been violated. Administrative agencies issue more rulings affecting business and settle more business disputes than courts do. Such agencies include the Securities and Exchange Commission, SEC, the Federal Communications Commission, FCC, and the Equal Employment Opportunity Commission, EEOC. Figure A.1 lists and describes the powers and functions of several administrative agencies at the federal, state, and local levels of government. Figure A.1 examples of federal, state, and local administrative agencies. Federal agencies, examples, powers and functions. Examples: Federal Trade Commission. Powers and functions: enforces laws and guidelines regarding unfair business practices and acts. Enforces laws and guidelines regarding unfair business practices and acts to stop false and deceptive advertising and labeling. Examples: Food and Drug Administration. Powers and functions: enforces laws and regulations to prevent distribution of adulterated or misbranded foods, drugs, medical devices, cosmetics, and veterinary products, as well as any hazardous consumer products. State agencies. Examples: Public Utility Commissions. Powers and functions: set rates that can be charged by various public utilities to prevent unfair pricing by regulated monopolies, like, for example, natural gas, electric power companies. Examples: State licensing boards, powers and functions. License various trades and professions within a state, like, for example, State Cosmetology Board, State Real Estate Commission. Local agencies, examples, Maricopa County Planning Commission, powers and functions, oversees land use proposals, long-term development objectives, and other long-range issues in Maricopa County, Arizona. Examples, City of Chesterfield Zoning Board, powers and functions, recommends policy regarding zoning of commercial and residential property in the City of Chesterfield, Missouri. Test prep. What is business law? What's the difference between statutory and common law? What is an administrative agency? Page 561, Tort Law, LOA-2. Define tort law and explain the role of product liability in tort law. A tort is a wrongful act that causes injury to another person's body, property, or reputation. Although torts often are non-criminal acts, courts can award victims compensation if the conduct that caused the harm is considered intentional. Legally, an intentional tort is a willful act that results in injury. The question of intent was a major factor several years ago in the lawsuits against the U.S. tobacco industry. Courts had to decide whether tobacco makers intentionally withheld information from the public about the harmful effects of their products. Negligence in tort law describes behavior that causes unintentional harm or injury. In a classic court finding of negligence, McDonald's lost a lawsuit to a customer severely burned by hot coffee bought at a drive-thru window. The jury felt that McDonald's failed to provide an adequate warning on the cup. The case became a flashpoint in the debate over product liability. Today, product liability remains a controversial area of tort law. So let's take a closer look at this issue. Product liability. Few issues in business law raise as much debate as product liability. Critics believe product liability laws have gone too far. Others feel these laws should be expanded. Product liability holds businesses liable for harm that results from the production, design, or inadequate warnings of products they market. Product liability holds businesses liable for harm that results from the production, design, or inadequate warnings of products they market. The average product liability case can cost businesses millions or billions, including defense costs, out-of-court settlements, and jury awards. At one time, the legal standard for measuring product liability was whether a producer knowingly placed a hazardous product on the market. Today, many states have extended product liability to the level of strict product liability, legally meaning liability without regard to fault. That is, a company that places a defective product on the market can be held liable for damages. A monetary settlement awarded to a person injured by another's actions. That is, a company that places a defective product on the market can be held liable for damages. A monetary settlement awarded to a person injured by another's actions, even if the company did not know of the defect at the time of sale. Page 562. Strict product liability is a major concern for businesses. More than 100 companies have been forced into bankruptcy due to asbestos litigation, and the issue is not yet closed. Johnson & Johnson agreed to pay $8.9 billion to settle tens of thousands of claims. Its talc-based baby powder caused cancer. Foreign companies are also subject to product liability claims. German giant Bayer faced more than 100,000 lawsuits involving its Roundup weed killer and paid out more than $11 billion. Some product liability cases have raised intriguing questions about responsibility. Gun manufacturers were sued by families of children killed in the Sandy Hook Elementary School massacre. Although a lower judge dismissed the legal claims, a higher court judge reinstated the case. Gun manufacturer Remington settled with the families for $73 million in 2022. Cities including Chicago and Miami had previously sued for the costs of police work and medical care necessitated by gun violence. McDonald's faced a product liability suit, also dismissed, claiming that its food caused obesity, diabetes, and other health problems in children. Some communities, however, have banned trans fats in food, regulated menu information, and eliminated toys and children's products like McDonald's Happy Meals. San Francisco once passed a law that required health warnings on advertisements for soda and other sugar-added drinks. The American Beverage Association filed a civil complaint to block the law, and an appeals court blocked enforcement. Many schools, however, have replaced soft drinks and vending machines with fruit, juice, and water. Tort and product liability reform remains a key objective of business. Congress took action with passage of the Class Action Fairness Act in 2005, which expanded federal jurisdiction over many large class action lawsuits. The legislation has been beneficial to some businesses since their cases were brought to federal court rather than state courts, where awards were typically much higher. Still, businesses and insurance companies argue that more needs to be done to assist companies with product liability. Consumer protection groups disagree and feel not enough is being done to protect consumers. Figure 8.2 highlights a brief history of several major past product liability awards that most companies dearly over many years. Figure 8.2 Major product liability cases. Company year settlement. Company Ford Motor Company year 1978 settlement, $125 million in punitive damages awarded in the case of a 13-year-old boy severely burned in a rear-end collision involving a Ford Pinto. Company A.H. Robbins year 1987 settlement, Dalkin Shield intrauterine birth control devices recalled after 8 separate punitive damage awards. Company settled over 6,900 cases for $200 million. Playtex Company 1988 suffered Playtex Company in 1988 suffered a $10 million damage award in the case of a toxic shock syndrome fatality in Kansas, forced to remove product from the market. Dow Corning in 1998 reached a settlement and agreed to pay $2 billion to customers who claimed silicone breast implants caused injury, even death. General Motors in 1999 suffered a $4.8 billion punitive award in a faulty fuel tank case. Major tobacco firms in 2004, $130 billion sought by the federal government for smoking cessation programs. Toyota in 2010, a safety feature known as brake to idle, fail safe, was not installed in many cars, increasing the chances of an accident when the accelerator malfunctioned. Company settled for $1.1 billion. Sources: U.S. Department of Justice and American Trial Lawyers Association. Page 563. Legally protecting ideas, patents, copyrights, and trademarks. LOA-3. Identify the purposes and conditions of patents, copyrights, and trademarks. Have you ever invented a product you think may have commercial value? Many people have. And to protect their ideas, they took the next step and applied for a patent. A patent is a document that gives investors exclusive rights to their inventions for 20 years from the date they file the patent applications. Patent applicants must make sure a product is truly unique and should seek the advice of an attorney. How good are your chances of receiving a patent if you file for one? About 52% of patent applications received by the United States Patent and Trademark Office, USPTO, are approved, with fees that vary according to the complexity of the patent. A patent dealing with complex technology can cost anywhere from $10,000 to $30,000, whereas a patent dealing with simpler concepts like a better mousetrap, it's estimated can cost the inventor about $5,000 to $10,000. Patent owners have the right to sell or license the use of their patent to others. Foreign companies are also eligible to file for U.S. patents. In fact, in 2022, Samsung had the highest number of patents registered in the United States, beating out IBM. Penalties for violating a patent infringement can be costly. In 2020, Apple and Broadcom were ordered to pay $1.1 billion to California Institute of Technology for infringing on 3 of the university's Wi-Fi patents, which had helped Apple stay competitive in the mobile phone market. Both companies appealed, and the court ordered a new trial held on the case. The USPTO does not take action on behalf of patent holders if patent infringement occurs. The defense of patent rights is solely the job of the patent holder. The American Inventors Protection Act was passed to require that patent applications be made public after 18 months, regardless of whether a patent has been awarded. This law was passed in part to address critics who argued that some inventors intentionally delayed or dragged out a patent application because they expected others to eventually develop similar products or technology. Then, when someone, usually a large company, filed for a similar patent, the inventor surfaced to claim the patent, referred to as a submarine patent, and demanded large fees for its use. The late engineer Jerome Lemelson reportedly collected more than $1.3 billion in patent royalties for a series of long-delayed patents, including forerunners of the fax machine, industrial robots, and the barcode scanner from auto, computer, retail, and electronics companies. Technology companies like Apple and Google have been the subject of lawsuits filed by patent trolls who license patents or buy the licensed patents and file infringement lawsuits against companies that often cost millions of dollars. The trolls never intend to use the patents. Their only intention is to file the lawsuits in the hopes of a financial settlement. Verizon, Honda, IBM, Google, and Cisco are among companies that have taken action to defend themselves against patent infringement suits by joining Allied Security Trust, a nonprofit firm that acquires intellectual property of interest to its members. The idea is to buy up patents that could impact their companies before they fall into the hands of others. The idea is to buy up patents that could impact their companies before they fall into the hands of others, mainly patent trolls, looking to pursue settlement or legal damages against the tech firms. Oracle, Google, Sergiotive, and Panther Media, GmbH, and Alamy Stock Photo. The computer technology firm Oracle battled with Google. The computer technology firm Oracle battled with Google in court for more than a decade over claims that the search giant violated copyright law. According to the lawsuit, Google developed the Android operating system using code that was owned by Oracle, an argument that a federal judge agreed with. Once the case made it up to the Supreme Court, though, Google's claims of fair use won over the justices in a 6-2 decision. Just as a patent protects an inventor's right to a product or process, a copyright protects a creator's rights to materials such as books, articles, photos, paintings, and cartoons. Copyrights are filed with the Library of Congress and require a minimum of paperwork. They last for the lifetime of the author or artist plus 70 years and can be passed on to the creator's heirs. The Copyright Act of 1978, however, gives a special term of 75 years from publication to works published before January 1st, 1978, whose copyrights had not expired by that date. The holder of a copyright can either prevent anyone from using the copyrighted material or charge a fee for using it. Author J.K. Rowling won a copyright violation suit against a fan who wanted to publish an unauthorized Harry Potter encyclopedia. If a work is created by an employee in the normal course of a job, the copyright belongs to the employer and lasts 95 years from publication or 120 years from creation, whichever comes first. A trademark is a legally protected name. Page 564. A trademark is a legally protected name, symbol, or design, or combination of these, that identifies the goods or services of one seller and distinguishes them from those of competitors. Trademarks generally belong to the owner forever, as long as they are properly registered and renewed. Trademarks generally belong to the owner forever, as long as they are properly registered and renewed every 10 years. Some well-known trademarks include the Aflac duck, Disney's Mickey Mouse, the Nike swoosh, and the golden arches of McDonald's. Like a patent, a trademark is protected against infringement. Businesses fight hard to protect trademarks, especially in global markets where trademark pirating can be extensive. They also work hard to gain the exclusive rights for a trademark. Coca-Cola, for example, attempted to trademark the rights to the word zero for its diet brand drinks for nearly 13 years before gaining approval in 2016. Unfortunately for Coke, a federal appeals court overturned that decision in 2018. Test prep. What is tort law? What is product liability? What is strict product liability? How many years is a patent protected from infringement? What is a copyright? Sales law, the Uniform Commercial Code, LOA-4, describe warranties and negotiable instruments as covered in the Uniform Commercial Code. At one time, laws governing businesses varied from state to state, making interstate trade extremely complicated. Today, all states have adopted the same commercial code. The Uniform Commercial Code, UCC, is a comprehensive commercial law that covers sales laws and other commercial laws. Since all 50 states have adopted the law, although it does not apply in certain sections of Louisiana, the UCC simplifies commercial transactions across state lines. The UCC has 11 articles which contain laws covering sales. The UCC has 11 articles which contain laws covering sales. Commercial paper such as promissory notes and checks, bank deposits and collections, letters of credit, bulk transfers, warehouse receipts, bills of lading, and other documents of title, investment securities, and secured transactions. We do not have space in this text to discuss all 11 articles, but we will discuss Article 2, which regulates warranties, and Article 3, which covers negotiable instruments. Warranties. A warranty guarantees that the product sold will be acceptable for the purpose for which the buyer intends to use it. There are two types of warranties. Express warranties are specific representations by sellers that buyers rely on regarding the goods they purchase. The warranty you receive in the box with an iPad or a toaster is an express warranty. Implied warranties are legally imposed on the seller, specifying that a product will conform to the customary standards of the trade or industry in which it competes. An implied warranty entitles you to expect that materials are product quality in an iPad. An implied warranty entitles you to expect that materials and product quality in an iPad will perform as expected when used according to published guidelines, or your toaster will toast your bread to your desired degree, light, medium, dark. Page 565. Warranties can be either full or limited. A full warranty requires a seller to replace or repair a product at no charge if the product is not functioning or defective, whereas a limited warranty typically limits the defects or mechanical problems the seller covers. Companies often offer extended warranties that provide more coverage, but for a price, of course. Many of the rights of buyers, including the right to accept or reject goods, are spelled out in Article 2 of the UCC. Mascot and Getty images. Would you buy a new car if the dealer offered no warranty? How about an iPhone or a major kitchen appliance with no guarantee of performance? Warranties are an important part of a product and are generally of major concern to purchasers. It's important to check whether a product's warranty is full or limited. Should colleges offer students warranties with their degree programs? Negotiable instruments. Negotiable instruments are forms of commercial paper, such as checks, that are transferable among businesses and individuals. They represent a promise to pay a specified amount. Article 3 of the Uniform Commercial Code requires negotiable instruments to follow 4 conditions. They must 1. Be written and signed by the maker or drawer. 2. Be made payable on demand or at a certain time. 3. Be made payable to the bearer, the person holding the instrument, or to a specific order. And 4. Contain an unconditional promise to pay a specified amount of money. Checks or other forms of negotiable instruments are transferred, negotiated for payment. When the payee signs the back, the payee's signature is called an endorsement. Contract law, LOA-5, list and describe the conditions necessary to make a legally enforceable contract and describe the possible consequences if such a contract is violated. If I offer to sell you my bike for $100 and later change my mind, can you force me to sell the bike by saying we had a contract? If I lose $120 to you in a poker game, can you sue in court to get your money? If I agree to sing at your wedding for free and back out at the last minute, can you claim I violated a contract? These are the kinds of questions contract law answers. A contract is a legally enforceable agreement between 2 or more parties. Contract law specifies what constitutes a legally enforceable contract. Contract law specifies what constitutes a legally enforceable agreement. Basically, a contract is legally binding if the following conditions are met. 1. An offer is made. An offer to do something or sell something can be oral or written. If I agree to sell you my bike for $100, I have made an offer. That offer is not legally binding, however, until the following other conditions are met. 2. There is a voluntary acceptance of the offer. The principle of mutual acceptance means that both parties to a contract must agree on the terms. If I use duress, coercion, through force or threat of force, in getting you to agree to buy my bike, the contract would not be legal. You couldn't use duress to get me to sell my bike either. Even if we both agree, though, the contract is still not legally binding without the next 4 conditions. 3. Both parties give consideration. Consideration means something of value. If I agree to sell you my bike for $100, the bike and the $100 are consideration, and we have a legally binding contract. If I agree to sing at your wedding and you do not give me anything in return, consideration, we have no contract. 4. Both parties are competent. A person under the influence of alcohol or drugs, or a person of unsound mind, one who has been legally declared incompetent, cannot be held to a contract. In many cases, a minor may not be held to a contract either. If a 15-year-old agrees to pay $15,000 for a car, the seller will not be able to force the contract due to the buyer's lack of competence. 5. The contract covers a legal act. A contract covering the sale of illegal drugs or stolen merchandise is unenforceable since such sales are violations of criminal law. If gambling is prohibited by state law in your state, you cannot sue to collect the poker debt. 6. The contract is in proper form. An agreement for the sale of goods worth $500 or more must be in writing. Contracts that cannot be fulfilled within 1 year also must be put in writing. Contracts regarding real property, land, and everything attached to it must be in writing. Page 566. Breach of contract. Both parties in a contract may voluntarily choose to end the agreement. A breach of contract occurs when one party fails to follow the terms of a contract. If that happens, the following may occur. 1. Specific performance. The party who violated the contract may be required to live up to the agreement if money damages would not be adequate. If I legally offered to sell you a rare painting, I would have to sell you that painting. 2. Payment of damages. If I fail to live up to a contract, you can sue me for damages, usually the amount you would lose from my non-performance. If we had a legally binding contract for me to sing at your wedding, for example, and I failed to come, you could sue me for the cost of hiring a new singer. 3. Discharge of obligation. If I fail to live up to my end of a contract, you can agree to drop the matter. Generally, you would not have to live up to your end of the agreement either. Lawyers would not be paid so handsomely if contract law were as simple as implied in these rules. That's why it's always best to put a contract in writing, even though oral contracts can be enforceable under contract law. The contract should clearly specify the offer and consideration, and the parties to the contract should sign and date it. A contract does not have to be complicated as long as 1. It is in writing, 2. It specifies mutual consideration, and 3. It contains a clear offer and agreement. Test prep. What is the purpose of the Universal Commercial Code, UCC? Compare express and implied warranties. What are the 4 elements of a negotiable instrument specified in the UCC? What are the 6 conditions for a legally binding contract? What can happen if a contract is breached? Promoting fair and competitive business practices. LOA-6 summarized several laws that regulate competition and protect consumers in the United States. Competition is a cornerstone of the free market system. See Chapter 1. A key responsibility of legislators is to pass laws that ensure a competitive atmosphere among businesses and promote fair business practices. The U.S. Justice Department's Antitrust Division and other government agencies serve as watchdogs to guarantee competition and market flows freely, and new competitors have open access to the market. The government's power here is broad. The Justice Department's Antitrust Division has investigated the competitive practices of market giants such as Apple, Visa, Meta Platforms, and Google. Microsoft's $68 billion purchase of video game producer Activision Blizzard is getting very close scrutiny from the Antitrust Division, as is the proposed merger of grocery giants Albertsons and Kroger. Figure 8.3 highlights several past high-profile antitrust cases. Figure 8.3 History of high-profile antitrust cases.
Case, United States versus Standard Oil, 1911. Outcome, Standard Oil broke up into 34 companies. Amoco, Chevron, and ExxonMobil are results of the breakup. United States versus American Tobacco, 1911. American Tobacco split into 16 companies. British Tobacco and R.J. Reynolds are results of the breakup. United States versus E.I. DuPont de Nemours, 1961. DuPont ordered to divest its 23% ownership stake in General Motors. United States versus AT&T. United States versus AT&T, 1982, settled after Ma Bell agreed to spin off its local telephone operations into 7 regional operating companies. United States versus Microsoft, 2000. Microsoft ordered to halt prior anti-competitive practices. Source: U.S. Department of Justice, page 567. Antitrust oversight was not always the rule. However, big businesses were once able to force smaller competitors out of business with little government resistance. The following brief history details how government responded to past problems and some new challenges government regulators face today. The history of antitrust legislation in the late 19th century. Big oil companies, railroads, steel companies, and other industrial firms dominated the U.S. economy. Some feared that such large and powerful companies would be able to crush any competitors and then charge high prices. In that atmosphere, Congress passed the Sherman Antitrust Act in 1890 to prevent large organizations from stifling the competition of smaller or newer firms. The Sherman Act forbids 1. Contracts, combinations, or conspiracies in restraint of trade, and 2. The creation of actual monopolies or attempts to monopolize any part of trade or commerce. Because some of the language in the Sherman Act was vague, there was doubt about just what practices it prohibited. To clarify its intentions, Congress enacted the following laws. The Clayton Act of 1914. The Clayton Act prohibits exclusive dealing, tying contracts, and interlocking directorates. It also prohibits buying large amounts of stock in competing corporations. Exclusive dealing is selling goods with the condition that the buyer will not buy from a competitor when the effect lessens competition. A tying contract requires a buyer to purchase unwanted items in order to purchase desired ones. Let's say I wanted to purchase 20 cases of Pepsi Cola per week to sell in my restaurant Harvest Gold. Pepsi, however, says it will sell me the 20 cases only if I also agree to buy 10 cases each of its Mountain Dew and Diet Pepsi products. My purchase of Pepsi Cola would be tied to the purchase of the other 2 products. An interlocking directorate occurs when a company's board of directors includes members of the board. An interlocking directorate occurs when a company's board of directors includes members of the boards of competing corporations. The Federal Trade Commission Act of 1914. The Federal Trade Commission Act prohibits unfair methods of competition in commerce. The legislation set up the 5-member Federal Trade Commission, FTC, to enforce compliance with the Act. The FTC deals with a wide range of competitive issues, everything from preventing companies from making misleading made in the USA claims to insisting funeral providers give consumers accurate itemized price information about funeral goods and services. Along with the Department of Justice, the FTC has the added responsibility to oversee proposed mergers and acquisitions. Chapter 5, to prevent anti-competitive mergers or acquisitions that would substantially reduce competition. The Wheeler-Leah Amendment of 1938 also gave the FTC additional jurisdiction over false or misleading advertising, along with the power to increase fines if its requirements are not met within 60 days. The Robinson-Patman Act of 1936, the Robinson-Patman Act prohibits price discrimination and applies to both sellers and buyers who knowingly induce or receive price discrimination. Certain types of price cutting are criminal offenses punishable by fine and imprisonment. That includes price differences that substantially weaken competition unless they can be justified by lowering. That includes price differences that substantially weaken competition unless they can be justified by lower selling costs associated with larger purchases. The law also prohibits advertising and promotional allowances unless they are offered to all retailers, large and small. Remember, this legislation applies to business transactions and not to business-to-consumer transactions. Page 568, Justin Sullivan and Getty Images News and Getty Images. Elizabeth Holmes founded the medical startup Theranos in 2003 after claiming she developed a revolutionary new way to conduct blood tests. She eventually became one of Silicon Valley's brightest stars as the company began to earn multi-billion-dollar valuations. But when an investigation found that Theranos' testing process did not work as advertised, Holmes' net worth quickly plummeted from $4 billion to zero. A trial followed soon after, where she was sentenced to more than 11 years in prison. The change in U.S. business from manufacturing to knowledge-based technology has created new regulatory changes for federal agencies. In the early 2000s, Microsoft's competitive practices were the focus of an intense antitrust investigation by the Justice Department. The government charged that Microsoft hindered competition by refusing to sell its Windows operating system to computer manufacturers that refused to sell Windows-based computers exclusively. The case ended with a settlement between the Justice Department and Microsoft that expired in 2011. Many antitrust advocates believe this specific case broadened the definition of anti-competitive behavior and proved the government's resolve in enforcing antitrust laws. It's safe to conclude, however, that antitrust issues will persist well into the future. Laws to protect consumers. Consumerism is a social movement that seeks to increase and strengthen the rights and powers of buyers in relationship to sellers. It is the people's way of getting a fair share and equitable treatment in marketing exchanges. The Public Company Accounting Reform and Investor Protection Act, better known as the Sarbanes-Oxley Act, was passed to allay concerns about falsified financial statements from companies like Enron and WorldCom in the early 2000s. The financial crisis of 2008 again fueled consumer anger, this time against the Treasury Department, Federal Reserve, and Securities and Exchange Commission, SEC, for their lack of oversight of the financial markets. The collapse of the real estate market, crisis in the banking industry, and failure of quasi-governmental mortgage agencies such as Fannie Mae and Freddie Mac led to the passage of the Dodd-Frank Wall Street Reform and Consumer Protection Act. The legislation created the Consumer Financial Protection Bureau that provides government oversight involving consumers in areas such as online banking, home mortgage loans, and high-interest payday loans. Figure 8.4 lists other major consumer protection laws over the years. Figure 8.4 Consumer Protection Laws. Fair Packaging and Labeling Act
1966, makes unfair or deceptive packaging or labeling of certain consumer commodities illegal. Child Protection Act, 1966, removes from sale potentially harmful toys and allows the FDA to pull dangerous products from the market. Truth in Lending Act, 1968, requires full disclosure of all finance charges on consumer credit agreements and in advertisements of credit plans. Child Protection and Toy Safety Act, 1969, protects children from toys and other products that contain thermal, electrical, or protects children from toys and other products that contain thermal, electrical, or mechanical hazards. Fair Credit Reporting Act, 1970, requires that consumer credit reports contain only accurate, relevant, and recent information and are confidential unless a proper party requests them for an appropriate reason. Consumer Product Safety Act, 1972, created an independent agency to protect consumers from unreasonable risk of injury arising from consumer products and to set safety standards. Magnuson-Moss Warranty Federal Trade Commission Improvements Act, 1975, provides for minimum disclosure standards for written consumer product warranties and allows the FTC to prescribe interpretive rules and policy statements regarding unfair or deceptive practices. Alcohol Labeling Legislation, 1988, provides for warning labels on liquor saying that women shouldn't drink when pregnant and that alcohol impairs a person's abilities. Nutrition Labeling and Education Act, 1990, requires truthful and uniform nutritional labeling on every food the FDA regulates. Consumer Credit Reporting Reform Act, 1997, increases responsibility of credit issuers for accurate credit data and requires creditors to verify that disputed data are accurate. Consumer notification is necessary before reinstating the data. Children's Online Privacy Protection Act, 2000, gives parents control over what information is collected online from their children under age 13, requires website operators to maintain the confidentiality, security, and integrity of the personal information collected from children. Country of Origin Labeling Law, 2009, requires that the product label on most food products sold in U.S. supermarkets gives the product's country of origin. Credit Card Accountability, Responsibility, and Disclosure Card Act, 2009, designed to protect consumers from unfair credit card practices. Page 569, Tax Laws, LOA-7, explain the role of tax laws in generating income for the government and as a method of discouraging or encouraging certain behaviors among taxpayers. Mention taxes and most people frown. Taxes are the way federal, state, and local governments raise money. They affect almost every individual in business in the United States. Page 570, governments primarily use taxes as a source of funding for the operations and programs. Taxes can also help discourage or encourage certain behaviors among taxpayers. If the government wishes to reduce consumer use of certain classes of products like cigarettes or liquor, it can pass sin taxes on them to raise their costs. To date, 21 states and the District of Columbia have adopted laws legalizing marijuana for recreational use. Expectations are new taxes levied on recreational marijuana will help their economies. 30 states have legalized some form of sports betting that is also helping increase states' coffers. In other situations, the government may encourage businesses to hire new employees. In other situations, the government may encourage businesses to hire new employees or purchase new equipment by offering a tax credit, an amount firms can deduct from their tax bill. Taxes are levied from a variety of sources: income taxes, personal and business, sales taxes, and property taxes are the major basis of tax revenue. The federal government receives its largest share of taxes from income. States and local communities make extensive use of sales taxes. School districts generally depend on property taxes. The tax policies of states and cities are important considerations when businesses seek to locate operations. They also affect personal decisions such as retirement. As government revenues at all levels continues to be challenging. As government revenues at all levels continue to be challenging, tax issues are debated. One such issue involves tax internet sales. Many states claimed they were losing billions in sales taxes by not collecting from internet sales transactions. The U.S. Supreme Court in 2018 opened the door to internet sales tax collections wider when it ruled a retailer can be required to collect sales taxes even if it does not have a physical presence in the state. Since then, almost all states have some tax online sales. Still, some businesses would prefer Congress to pass a law that would set uniform rules for sales tax collections. Figure 8.5 highlights the primary types of taxes levied on individuals and businesses. Figure 8.5, types of taxes. Types of taxes. Type, purpose. Type, income tax. Purpose, taxes paid on the income received by businesses and individuals. Income taxes are the largest source of tax income received by the federal government. Property taxes. Taxes paid on real and personal property. Real property is real estate owned. Real property is real estate owned by individuals and businesses. Personal property is a broader category that includes any movable property such as tangible items, wedding rings, equipment, etc., or intangible items, stocks, checks, mortgages, etc. Taxes are based on their assessed value. Sales taxes, taxes paid on merchandise sold at the retail level. Excise taxes, excess taxes, taxes paid on selected items such as tobacco, alcoholic beverages, airline travel, gasoline, and firearms. These are often referred to as sin taxes. Income generated from the tax goes toward a specifically designated purpose. For example, gasoline taxes often help the federal government and state governments pay for highway construction or improvements. Bankruptcy laws, LOA-8, distinguish among the various types of bankruptcy as outlined by the Bankruptcy Code. Bankruptcy is the legal process by which a person, business, or government entity unable to meet financial obligations is relieved of those debts by a court. Courts divide any of the debtor's assets among creditors, allowing them to recover at least part of their money and freeing the debtor to begin anew. The U.S. Constitution gives Congress the power to establish bankruptcy laws, and legislation has existed since the 1890s.
Major amendments to the Bankruptcy Code include the Bankruptcy Amendments and Federal Judgeship Act of 1984, the Bankruptcy Reform Act of 1994, and the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. Page 571, the 1984 law allows a person who is bankrupt to keep parts of the equity ownership in a house and car and some other personal property. The 1994 Act amended more than 45 sections of the Bankruptcy Code and created reforms to speed up and simplify the process. The Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 was passed to reduce the total number of bankruptcy filings and to eliminate the perceived ease of filing for bankruptcy. The legislation increased the cost of filing and made it difficult for people, especially those with high incomes, to escape overwhelming debt from credit cards, medical bills, student loans, or other loans not secured through a home or other asset. It also requires debtors to receive credit counseling. Bankruptcies started growing in the late 1980s and have increased tremendously since. Many attributed the increase to a lessening of the stigma of bankruptcy, an increase in understanding of bankruptcy law and its protections, and an increase in advertising by bankruptcy attorneys. Some suggest that the ease with which certain consumers could get credit contributed to the number of filings by allowing people to readily overspend. The 2005 reform helped reduce the annual number of bankruptcy filings to 600,000 from an average of $1.5 million between 2001. The 2005 reform helped reduce the annual number of bankruptcy filings to 600,000 from an average of 1.5 million between 2001 and 2004. However, the financial crisis of 2008 pushed the number of bankruptcies again to over 1 million. As the economy slowly recovered from the financial crisis, bankruptcies stayed over $1 million. As the economy slowly recovered from the financial crisis, bankruptcies stayed over 1 million until 2015, when numbers began to decrease. In 2020 and 2021, bankruptcies decreased thanks to government assistance provided during the COVID-19 pandemic. Although high-profile bankruptcies of businesses such as JCPenney, Toys R Us, and Neiman Marcus tend to dominate the news, 97% of bankruptcy filings each year are by individuals. Sears, UPI, and Alamy stock photo. Sears, once the largest retailer in the United States, filed for bankruptcy in 2018 after years of declining sales. The company sought Chapter 11 protection again in 2022, leaving the once mighty Sears with only a handful of stores remaining. Do you know of any other companies that have been forced into bankruptcy? Bankruptcy can be either voluntary or involuntary. In voluntary bankruptcy, the debtor applies for bankruptcy. In involuntary bankruptcy, the creditors start legal action again. In voluntary bankruptcy, the debtor applies for bankruptcy. In voluntary bankruptcy, the creditors start legal action against the debtor. Most bankruptcies are voluntary since creditors usually wait in hopes they will be paid all the money due them rather than settle for only part of it. Bankruptcy procedures begin when a petition is filed with the court under one of the following sections of the Bankruptcy Code. Chapter 7, Straight bankruptcy or liquidation used by businesses and individuals. Chapter 11, Reorganization used almost exclusively. Chapter 11, Reorganization used almost exclusively by businesses.
Chapter 13, repayment used by individuals. Chapter 7 is the most popular form of bankruptcy among small businesses. It requires the sale of non-exempt assets. States can choose different exemption statutes. When the sale of assets is over, creditors, including the government if taxes are owed, divide the remaining assets as stipulated by law. First, creditors with secured claims receive the collateral for their claims or repossess the claimed asset, such as an automobile, equipment, or building. Then unsecured claims backed by no asset are paid in this order. 1. Costs of the bankruptcy case. 2. Any business costs incurred after bankruptcy was filed. 3. Wages, salaries, or commissions owed. 4. Contributions to employee benefit plans. 5. Refunds to consumers who paid for products that weren't delivered. 6. Federal and state taxes. Figure 8.6 outlines the steps used in Figure 8.6 outlines the steps used in liquidating assets under Chapter 7. Page 572, Figure 8.6, how assets are divided in bankruptcy. This figure shows that the creditor, the person owed money, selects the trustee, the person of organization. This figure shows that the creditor, the person owed money, selects the trustee, the person or organization that handles the sale of the assets. Note that the process may be started by the debtor or the creditors. Voluntary debtor petitions bankruptcy court for bankrupt status. Creditors elect trustee. Trustee converts assets to cash. Necessary expenses and priority claims are paid. Remaining cash is divided among unsecured creditors. Involuntary. Creditors start legal action against debtor. Debtor must answer creditors' charges. Case dismissed due to lack of evidence. Or the debtor must answer creditors' charges. Creditors elect trustee. Trustee converts assets to cash. Necessary expenses and priority claims are paid. Remaining cash is divided among unsecured creditors. In Chapter 11, bankruptcy, a company sued by creditors continues to operate under court protection while it tries to work out a plan for paying off its debts. Under certain conditions, it may sell assets, borrow money, and change company officers to strengthen its market position. A court-appointed trustee supervises the proceedings and protects the creditor's interests. A company does not have to be insolvent to file for relief under Chapter 11. In theory, it is a way for sick companies to recover, designed to help both debtors and creditors find the best solution. In reality, however, less than 1/3 of Chapter 11 companies survive, usually those with lots of cash available. The Bankruptcy Reforms Act of 1994 provides a fast-track procedure for small businesses filing under Chapter 11. The Small Business Reorganization Act of 2019, SBRA, came into effect in February 2020. The goal of Subchapter 5 of the SBRA was to simplify the bankruptcy process for small businesses by increasing efficiency, lowering costs, and easing the process. Chapter 13 permits individuals, including small business owners, to pay back creditors over 3 to 5 years. Chapter 13 proceedings are less complicated and less expensive than Chapter 7 proceedings. The debtor files a proposed plan with the court for paying off debts. If the plan is approved, the debtor pays a court-appointed trustee in monthly installments as agreed on in the repayment plan. The trustee then pays each creditor.
Deregulation versus Regulation, LOA-9, explain the role of deregulation as a tool to encourage competition. The U.S. Constitution gives Congress the right to regulate commerce. The debate concerning the degree of regulation, however, has been a source of disagreement for many years. At one time, the United States had laws and regulations covering almost every aspect of business. Some felt there were too many laws and regulations costing the public too much money. A movement toward deregulation took hold. Deregulation means that the government withdraws certain laws and regulations that seem to hinder competition. The most publicized examples of deregulation first occurred in the airline and telecommunications industries. Page 573. Consumers clearly benefited from the Airline Deregulation Act of 1978 that ended federal control of commercial airlines. Before passage of the act, the government restricted where airlines could land and fly. When the restrictions were lifted, airlines began competing for different routes and charging lower prices. These skis were also opened to new competitors such as Southwest and JetBlue to take advantage of new opportunities that were created. Passage of the Telecommunications Act in 1996 brought similar deregulation to telecommunications and gave consumers a flood of options in local telephone service markets. There was also a significant increase in retail video competition. At one time, most homes received only 4 TV channels. The 3 major networks, NBC, CBS, and ABC, and public broadcasting. Today, most households receive multiple over-the-air networks and hundreds more on cable, satellite, and online streaming services. Deregulation efforts also occurred in the electric power industry. California was the first state to deregulate electric power in the late 1990s and experienced significant problems, especially with large-scale blackouts, loss of power. This caused other states to question the logic of deregulation. Today, however, 34 states have fully or partially deregulated electric power markets. The financial crisis reopened the question of how much deregulation is too much. Deregulation in the banking and investment industries had changed the nature of financial and mortgage markets and created Deregulation in the banking and investment industries had changed the nature of financial and mortgage markets and created huge problems. The Federal Reserve System's reluctance to toughen mortgage regulations and the government's insistence on providing more home loans to high-risk borrowers contributed to the collapse in the real estate market. The financial crisis that followed led to the passage of the most sweeping regulation of financial markets since the Great Depression. In 2010, the U.S. Congress passed the Patient Protection and Affordable Care Act, PPACA, also known as Obamacare. The law, implemented in 2013, introduced a comprehensive system of health insurance for Americans not covered under an insurance plan. The law also provides for increased government regulation of the insurance industry. While the Affordable Care Act increased the number of people with health care insurance, it also increased prices for many consumers and caused other dissatisfaction. Congress repealed the mandate provision that required individuals to purchase health care insurance. If they didn't already have it, but the rest of the law stayed in place. In 2021, the U.S. Supreme Court rejected a challenge to the Affordable Care Act for the 3rd time, ending most opposition. Most agree some regulation of business is necessary to ensure fair and honest dealings with the public. Corporate scandals and the financial crisis led consumers and investors to call for increased government regulation in the financial sector. With increasing global competition, U.S. business will need to work with government to create a competitive environment that is fair and open and accepts responsibilities to all stakeholders. Test prep. What is the primary purpose of antitrust law? Describe the different bankruptcy provisions under Chapter 7, Chapter 11, and Chapter 13. What is deregulation? Give examples of successful and unsuccessful deregulation. Page 574, Summary. LOA-1, Define business law, distinguish between statutory and common law, and explain the role of administrative agencies. What is the difference between statutory law and common law? Statutory law includes state and federal constitutions, legislative enactments, treaties of the federal government, and ordinances, in short, written law. Common law is the body of unwritten law that comes from decisions handed down by judges. What are administrative agencies? Administrative agencies are federal or state institutions and other government organizations created by Congress or state legislatures with power to create rules and regulations within their area of authority. LOA-2, Define tort law and explain the role of product liability in tort law. What is an intentional tort? An intentional tort is a willful act that results in injury. What is negligence? Negligence in tort law is behavior that causes unintentional harm or injury. Findings of negligence can lead to huge judgments against businesses. LOA-3, Identify the purposes and conditions of patents, copyrights, and trademarks. What are patents and copyrights? A patent is a document that gives inventors exclusive rights to their inventions for 20 years from the date they file the patent applications. A copyright protects a creator's rights to materials such as books, articles, photos, paintings, and cartoons. What is a trademark? A trademark is a legally protected name, symbol, or design, or combination of these, that identifies the goods or services of one seller and distinguishes them from those of competitors. LOA-4, Describe warranties and negotiable instruments as covered in the Uniform Commercial Code. What does Article 2 of the UCC cover? Article 2 contains laws regarding warranties, express warranties, and guarantees made by the seller, whereas implied warranties are guarantees imposed on the seller by law. What does Article 3 of the UCC cover? Article 3 covers negotiable instruments such as checks. A negotiable instrument must 1. Be written and signed by the maker or drawer. 2. Be made payable on demand or at a certain time. 3. Be made payable to the bearer, the person holding the instrument, or to specific order. And 4. Contain an unconditional promise to pay a specified amount of money. Page 575. LOA-5, List and describe the conditions necessary to make a legally enforceable contract and describe the possible consequences if such a contract is violated. What makes a contract enforceable under the law? An enforceable contract must meet 6 conditions. 1. An offer must be made. 2. The offer must be voluntarily accepted. 3. Both parties must give consideration. 4. Both parties must be competent. 5. The contract must be legal. And 6. The contract must be in proper form. What are the possible consequences if a contract is violated? If a contract is violated, one of the following may be required. 1. Specific performance. 2. Payment of damages. Or 3. Payment of damages. Or 3. Discharge of obligation. LOA-6, Summarize several laws that regulate competition and protect consumers in the United States. What does the Sherman Act cover? The Sherman Act forbids contracts, combinations, or conspiracies in restraint of trade and actual monopolies or attempts to monopolize any part of trade or commerce. What does the Clayton Act add? The Clayton Act prohibits exclusive dealing, tying contracts, interlocking directorates, and buying large amounts of stock in competing corporations. Which act regulates false and deceptive advertising? The Federal Trade Commission Act prohibits unfair methods of competition in commerce, including deceptive advertising. Which act prohibits price discrimination and demands promotional allowances? The Robinson-Patman Act applies to both sellers and buyers who knowingly induce or receive an unlawful discrimination in price. LOA-7 explain the role of tax laws in generating income for the government and as a method of discouraging or encouraging certain behaviors among taxpayers. How does the government use taxes to encourage or discourage certain behavior among taxpayers? If the government wishes to change citizens' behavior, it can reduce their use of certain classes of products, cigarettes, liquor, by passing sin taxes to raise their cost. In other situations, the government may offer tax credits to encourage businesses to hire new employees or purchase new equipment. LOA-8 distinguish among the various types of bankruptcy as outlined by the Bankruptcy Code. What are the bankruptcy laws? Chapter 7 calls for straight bankruptcy, in which all assets are divided among creditors after exemptions. Chapter 11 allows a firm to reorganize and continue operation after paying only a limited portion of its debts. Chapter 13 allows individuals to pay their creditors over an extended period of time. LOA-9 explain the role of deregulation as a tool to encourage competition. What are a few of the most publicized examples of deregulation? Perhaps the most publicized examples of deregulation have been those in the airline, telecommunications, electric power, financial services, and healthcare industries. Page 576, key terms: administrative agencies, bankruptcy, breach of contract, business law, common law, consideration, consumerism, contract law, copyright, damages, deregulation, express warranties, implied warranties, involuntary bankruptcy, judiciary, negligence, negotiable instruments, patent, precedent, product liability, statutory law, strict product liability, taxes, tort, Uniform Commercial Code, UCC, voluntary bankruptcy. Critical thinking. 1. Supporters of tort reform say it's unfair that plaintiffs, the parties bringing lawsuits, don't have to pay damages to the defendants, the parties subject to the lawsuits, if they lose the case. Should plaintiffs pay damages if they lose a case? Why or why not? 2. Go to the website of the U.S. Patent and Trademark Office, uspto.gov, and view the information about obtaining a patent. See whether you can estimate how long the process will take and what your cost will be. 3. Call your local real estate board or visit a realtor and obtain a copy of a real estate contract. Read it carefully to see how it meets the 6 requirements stated in the chapter for a contract to be legal and binding. 4. Has your state or neighboring state implemented utility deregulation? How does it seem to be working? Putting principles to work. Purpose. You and several of your musician friends decide to start a band. You want to call the individual Mandates. You want to protect the band name and the new songs you've written so that other groups can't use them without your permission. Go to the U.S. Patent and Trademark Office's website, uspto.gov, to find out how to get the protection you seek. Exercise. 1. Do you need to apply for patents, copyrights, or trademarks, or some combination of these to protect your brand name and songs? 2. When can you use the trademark symbols? And 3. How can you secure a copyright for your songs? 4. What are the advantages of registering copyrights? Page 577, Developing Career Skills. Key, team, analytic, communication, technology. 1. Do you think the laws that promote fair and competitive practices are effective in the United States? Why or why not? Provide evidence for your view. 2. Increasing numbers of individuals and businesses file for bankruptcy each year. Do you think the U.S. Congress was correct in toughening the bankruptcy laws? 3. Divide the class into teams to debate the question, should government action Divide the class into teams to debate the question, should government action to deal with deceptive business practices increase, or should we count on business to regulate itself to prevent deceptive practices? Which solution seems better for society and business in the long run? 4. Go online to find answers to the following questions. Does your state have an income tax? What percentage of your income do you have to pay in state income tax? What about property taxes and sales taxes? How do these taxes in your area compare to those in 3 other states and communities of your choice? 5. Chapter 11. Bankruptcy allows businesses to continue operating under court protection while they try to pay off their debts. Search online and find 3 companies that came back from Chapter 11 and regained their stature in the market. Explain why they were successful. Career exploration. If you are interested in working in the legal environment, here are a few careers to consider. Find out about the tasks performed, skills needed, pay, and opportunity outlook in these fields in the Occupational Outlook Handbook, OOH, at bls.gov. Arbitrator and mediator. Facilitate negotiation and dialogue between disputing parties to help resolve conflicts outside the court system. Court reporter. Creates word-for-word transcriptions at trials, depositions, and other legal proceedings. Some court reporters provide captioning for television and real-time translation for people who are deaf or hearing impaired at public events, in business meetings, or in classrooms. Lawyer. Advises and represents individuals, businesses, and government agencies on legal issues and disputes. Paralegal and legal assistant perform a variety of tasks to support lawyers, including maintaining and organizing files, conducting legal research, and drafting documents. Page 578, Notes. Bonus Chapter B, Using Technology to Manage Information, page 579.